Today on the Chamber, we take a look at employment contracts and their significance. And like I mentioned earlier, my guest is George Tetewayo, and he's a lawyer from BCMS Consulting. Good morning, George.
Good morning, madam.
Is it okay if I call you George?
Yeah, that's fine.
All right. So we're looking at employment contracts. Can you just explain a little bit exactly what an employment contract is for us?
Thank you very much. Let me say good morning to your cherished viewers. Generally, when we look at employment in its simple form, the laws in our country are diverse, but the Labor Act 2003 Act 651 seems to regulate all aspects of employment, because that is the major law on the labor front. If you look at section 12 of that act, what that means is that you are looking at the various provisions, and that talks about contract of employment. All what it seeks to do is that when somebody is in employment for a certain number of days, that goes to a period of 6 months or more, or that person is working for some days, they might not be in successive, but the number of days, but that will add up to 6 months or more in a particular year, then the law is saying that that engagement should be in written form, and that is what we call the contract of employment.
So anything above 6 months,
yes,
any work that you engage in that goes beyond 6 months.
In 1 year, if I'm working for you for a number of days and it's up to a period of 6 months, then the law is saying that it must be put into writing.
Into writing. So all employment contracts come in the form of writing.
Absolutely.
It must be written.
Absolutely.
It can't be an oral.
Absolutely. It must be written.
Okay.
And the reason why it must be written is that subsection 2 of the same section 12 says that the terms and obligations of the employer and the employee will be expressly stated in this written document.
Okay, so it can't be an oral agreement between the two.
No, that will not come, or that will not fly under the act.
Okay.
So that what terms, what obligations are we looking at?
Okay.
Because in every contractual agreement, there should be some terms in that agreement. So you have set up a company and you want me to work for you. What are the obligations on me as a worker?
Okay, so the terms must be expressly stated
in that document. So that is
okay,
why there's a need to have that contract of employment.
Okay. What other thing must be stated in this employment contract?
So generally, like I'm saying, is the terms. So for example, if we use TV3, you are a media house. So everything that goes in here will be about the media, so that you don't bring somebody's son or daughter here and the person will begin to be painting. You understand? The person will begin to be doing producing soap. So what that simply means is that based on the nature of the employment, the terms and obligation is very important. So the obligation is you are employed to come to work at this time, but you are scheduled to do A, B, C, D.
Okay, and so this is something that's agreed upon by both parties?
By the parties. So it depends on the company, but they are either obligations alongside the terms. So the obligations will be, if it's for the worker, what is the worker supposed to do? What are my scheduled times of operation? And then the terms will be, okay, because you are working so and so number of hours in a day for a month, you are getting this remuneration and all that. Those terms will come. Then the number of holidays or leisure times you get, or maybe at certain times, if you become maybe the best worker in the year or in the month, you are given certain privileges. All those terms will come. So it depends. So there's no straight jacket terms and obligation. It depends on
what the two parties agree on. And is this what we call conditions of service?
Absolutely.
Okay. And
but the law says the contract of employment.
Okay. So where does the conditions of service come in? Is that a separate document?
No. The contract of employment embodies the entire transaction between the worker and then the employer.
Okay.
And the conditions under which you are going to work is embedded into that contract. That is what's going to come under the obligations,
okay,
and then the terms.
Okay.
So for example, one condition is that in this company we uphold the health of our workers, so we're giving them leisure periods for them to go out there and holiday.
Okay.
And that condition is there, but it's couched under the terms of the contract of employment.
Right.
And the law is also saying that when that is done, section 13 is saying that 12 is talking about the contract of employment, 12(1) and 2 saying that it must be expressed, and 13 is saying that when that has been done, there should be a written statement. So after we have agreed, within 2 months, I should give you a copy of that contract as a worker, so that you know that these are my obligations and these are the terms I'm going to enjoy under this obligation. So the law also goes ahead to indicate that after 2 months into that employment,
the employee must be given a
absolutely
copy of this contract. Okay, what about the collective agreement? What is the collective agreement, and when does this come in?
Absolutely. When you talk about collective agreement, you are moving towards more or less like a tripartite form of disposition, whereby you are bringing in trade unions, you are bringing in other dimension. But normally, contract of employment is normally between the employer and the employee,
okay.
The two of them.
Right.
But when we go beyond the employer and the employee, and we are looking at
this is the workplace, the
TUC, we are looking at AGI, we are looking at all other parties that come under the umbrella of the labor front to make sure that how is labor in Ghana being looked at. Then we are going outside the I wouldn't say skeleton, but the little area of contract of employment to a collective agreement, where for instance you have the tripartite committee coming in and all these matters.
And must your contract of employment conform with that of the collective agreement, or there can be a variation of sorts?
Yeah, so that for example, if the TUC says that the minimum wage in Ghana should be 5 Ghana cedis, and at that level is agreed upon, when that is seen and the National Tripartite Committee comes in and that is done, collectively as workers of Ghana, the labor front is saying that the minimum wage is 5 cedis.
Okay.
Now, when you descend that to your company and your worker, then you reflect that notion of the minimum wage into your contract of employment as to the standard or the agreed figure that a worker in Ghana is supposed to take.
Okay. Now let's talk about the obligations of the employer. What are some of the obligations that the employer has to that are contained in the contract of employment?
Thank you very much. Like I indicated, if you're looking at the contract of employment, because it's going to look at the obligations of the worker and the employer, and then also the terms upon which you'll be working, that document cannot basically contain entirely what must be done. The reason is that the law have captured those areas. So sometimes what lawyers do is that you want to, in a summary, put those obligations in a bulletin form, but the law has taken care of that. So if you want to find out what an employer in Ghana is supposed to do, that way you come back to the Labour Act, because there's a law on it. So the law is giving the employer an obligation, a duty, at the same time a right. The same law is giving the worker the employee, a duty and a right. So when it comes to Section 8, if you take the entire Part 3 of the Labour Act, Act 651, it talks about protection of employment, and Section 8 all the way down. So 8 talks about the rights of a worker, 9 talks about the duties of a worker, 10 in that order will talk about the rights of the right of the employer, and then the duty of the employer, then the right of the worker, the duty of the employer. So if you take the employer, for example, the employer, it is the right of the employer to hire you, and when he hires you, it's the right of the employer to discipline you. It's the right of the employer to transfer you. TV3, we've set up a new station in Tamale. We want to send you there. The employer has the right to transfer you to Tamale, so long as you want to remain a staff of TV3. You're not supposed to be here. So
these are the rights of the employer. Yes. The things that he has a right to
modify his operations.
So right to hire, right to you mentioned transfer.
Right to discipline you, right to enhance your livelihood. There's a right to modify your operations. Now that we are moving in a digital world, can we still be at the manual? Let's modify our operations. Right to decide the product you are bringing out and charges. That's why if you come to TV3 will charge you how much you have to pay for airtime and all that. All these are the rights of the employer.
Now, and termination as well. The employer has the right to terminate
your contract based on the law, as it says that maybe you are lazy or maybe you are not pulling your weight and all that. But the law also enjoins the employer to also have some obligation. The obligation is that you must provide the materials, the machineries, the equipment at the standard that at the time the employee is in work, it needs them. So for example, if I'm a farmer and we are moving in a digital age and we need tractors, and you still give me a hoe and cutlass on that huge plantation, let me use Ghana Rubber Estate, and you give me a cutlass at Ghana Rubber Estate, it won't wash. Because if you look at the operations of Ghana Rubber Estate, it's a huge plantation, and at this level we need machineries. So it's the duty of the worker, the employer, to provide the employee the right materials
to enable them to work.
Absolutely. It's a duty to provide a good and safe, healthy environment. It's a duty to enhance the welfare of your workers. It's a duty to pay the agreed remuneration at the right time and the place it must be paid. All these are your obligations. And if you come to the employee, that's the worker, The worker also has the right to work at a comfortable environment, have right to have leisure and holidays, have right to receive equal pay for salary, the same equal pay for equal work without discrimination and all that. Then the same worker or the employee also has a duty. Your duty to come to work early, punctual and regular. Your duty to protect the interests of your employer. Your duty to enhance and improve productivity. All these are, vis-a-vis in protecting the employment as a whole.
Okay. When we get these employment contracts, are there any hidden things that we need to look out for? Are there any hidden language or hidden words or anything at all that one must look out for?
Absolutely. It's very important. So you asked a question earlier that should lawyers come in to assess. That is when I think if you want to get these things, when you are giving, you have to take it to your lawyer to look at it for you and see if these terms and agreements are favorable. But sometimes what employers do is that they want to put in some clauses, call them exemption clauses, and that will seek to keep a certain right to the owner of the company.
Can you give us an example of such a clause?
For example, let's say family members are not more or less accepted at these premises. However, when you know that sometimes there will be the need for persons to be visited, but then you put in a clause that is so stringent that your worker cannot have a visitation. Let's say visitation, where you want to block a certain communication channel between your worker and the people family out there. Would it be so good to do that, or there should be a certain leeway? You understand? So what I'm trying to say is that it depends, and each company and certain clauses they want to put in. But our law is also clear and prohibits. So a clear example is also maybe trade unions. Some companies, for one or two reasons, want to prohibit you from joining trade unions or forming trade unions. These are not accepted by the law. Right. You understand? Because the worker has the right to join, and Article 21 of our law says that you have the right, freedom of association.
So these are some of the things that the lawyer will be able to look at and then point them out to you and advise you accordingly.
So if you come to the Labour Act, we call it prohibition of restrictive conditions. That the worker is not to be given a contract that contains restrictive conditions, like don't join this trade union, but join trade union A. You can't join trade union B, but join A. Those terminologies, you understand? Right. So that your lawyer will be able to assist you to know whether you can take that employment or base. For example, maybe if you are an SDA person and you have certain beliefs, and then your employment is saying something else, you just support that with your religious belief and see whether you can take that employment or you refuse it. So these are the
okay. What legal options is available for an individual who doesn't actually sign a contract, but based on a verbal agreement executes work for an employer?
In law, oral contracts are binding. They are always having effect based on the circumstances at the time. So that if the law is saying that we must put it into writing, because I'm working for a period more than 6 months in a year, and I've worked for 7 months, 8 months, and I don't have that. What that will mean is that we have just breached a portion of the law, but it doesn't mean that the contract to work for you has not been executed. The law will look at the facts on the ground, so that if for 8 months I've been coming to TV3 every day and I've been signing the attendance or the rule, whatever mode there is, I've been signing in and out, and for 8 months I've been doing this, it is clear that per the fact I've been working for 8 months, the fact that we have not entered that contract and then signed it for you to give me a copy will not defeat the fact on the ground that I've worked for you for 8 months and I need to be paid. So oral agreements are binding, but it is risky. So that is why it always comes back to the point that in these matters, moving forward as a nation, it's always good for citizenry to know the laws governing every disposition they want to. If you want to go for employment, the Labour Act, I mean, today in this, I can see your tablet here. You can just go there and type Labour Act of Ghana, and it will be there. And then you understand what governs employment in Ghana as you go out there to seek for employment.
So it's a good thing for all employees to at least have some fair knowledge about the Labour Act. When
it comes to issue of termination, and then some few months ago we heard the mining companies trying to terminate, and we have lawful termination and unlawful termination. You understand? It's not every termination that is unlawful or illegal. Right. You understand? When the company wants to retrain and then readjust, it has the power
to do that. Fine, let's talk a bit about termination before you go. Under what grounds can an employer terminate an employee's contract or Yes.
The termination of a contract can be terminated mutually. So in the first place, both parties, I'm working for you. I wake up tomorrow, I say I'm tired. I don't want to go back to TV3 anymore. Okay, fine, I'm not working. So you come and speak to whoever is in charge, and we have mutually agreed. It's been terminated.
Even though there's a contract in place?
Yes, we've mutually agreed. It's terminated. Because you can't force the worker to work for you.
No warning, you don't need to give notice, a certain days, number of days notice.
You come to that. But the process is that we can terminate by a mutual agreement.
Okay.
Secondly, now, when you take the mutual agreement out, the rest is on the employer. Because most of the time, it's the employer who is the investor, who has pumping money. So, to terminate hinges more on him or her. But the mutual one is because maybe the worker feels that fine. And the worker will do that.
But the worker is also giving their time and their know-how and expertise and everything to the job. So
yeah, but in this employment environment, it's always seems like somebody is looking for employment, and when he gets it,
so the employer always has the upper hand.
Absolutely. So when it comes to the mutual one, the two of them are agreeing that we are not going on with the contract anymore because maybe I'm tired, maybe I'm ill, maybe I'm sick. But when it comes to the employer, the owner of the company, he or she can terminate based on lack of performance. So if per your performance on record, you are not pulling your weight, then the employer alone can decide that I'm moving towards terminating. Absenteeism, not being punctual at work, not meeting the quota that you're supposed to meet with regard to the actual work on the ground. You are a cameraman and you are supposed to come and then do the work, and then we are set and you are nowhere to be found and all that. The employer can decide that no, this employee must go. You understand? Okay. So these are the various connotations. But then you are asking if there is any notification. Notice is paramount. It's also part of the law. The notice is with regards to if you are in an employment that is for 3 years and above, then you need to give 1 month notice to each party. And in lieu of the 1 month, the 1 month notice to each party, in lieu of the 1 month, you pay for that 1 month.
You pay the employee salary for that
for one month. That is both ways. So that if yes, the mutual agreement, okay. you the employee, the worker who thought you are tired, maybe you want to go somewhere, you've gotten
you pay a month's salary to your employer.
Of course, because you are terminating.
So but usually all these grounds and procedures for terminating a contract will be contained in your contract of employment, wouldn't it?
Absolutely, and it is just a replica of what is in the law. That is why when you give it to your lawyer, he will see that fine has what been put on paper, what the law is saying. So whatever is in that contract of employment is basically what the law is saying. Because we will draft these are legal documents. So you draft these documents based on the existing law. So these terms you are asking for, let me just try to answer by saying that yes, they will be in the contract of employment, but they are just a repetition of what is in the law. You understand? And it is saying that if you want to mutually terminate, 1 month notice. Both sides. The boss must give in 1 month notice. So the boss will use that 1 month to get a replacement for you. You want to go overseas. You've gotten maybe your own idea and then you want to go. You cannot leave the workplace in the vacuum. So you give 1 month notice so that the boss, like you're sitting here now, if you want to leave, you have to give 1 month notice so they will replace you to come and do this fantastic work we are doing. In lieu of that, you pay them. So that way. So these are the very things that will be repeated in the contract of employment to become a document. So it's not like new ideas will be put into the contract of employment that is different from what's in the law.
Okay, so this is when it's a mutual agreement. What if it's not? It's one party that wants to terminate the contract.
And like you said, the greater one coming from the owner of the company because of maybe absenteeism, lateness, you are not working, ill health, you understand, that you cannot go on. Then the boss must tell you that you are too ill, you can't continue. If you keep you here, your health will deteriorate. So we will politely want you to resign or want you to leave the employment. 1 month notice so that the worker will come to terms with the situation. And then but what is interesting is that there's remuneration for termination. When that is done, the first thing is that you pay the worker all remuneration due before the date of termination. You pay all deferred payments. If there are some deferred payment, maybe some allowances, some other public, other things you have not paid, you pay those ones before the expiration. And then if there's any compensation, that must be given as well. So we are looking at 2 or 3 issues. You are paying outstanding remuneration that the worker is due. You are paying any deferred monies that is owed the worker or the employee. You are paying any compensation thereof for the employee to meet this termination that has come up.
Finally, I understand there's a difference between a dismissal and a termination. Can you touch a little bit on that?
These are These are the Queen's language. So we want to explain, and definitely in law, when we want to interpret, we use an ordinary and natural meaning. The natural meaning of termination is to bring short, or is to cut short, to bring to an end. And we are saying that in the labor arena, we cannot bring a contract to an end based on some of the things I've told you. When we want to mutually agree to go our separate ways, then we can bring it to an end. When there's absenteeism on my part, I'm not working hard, then we can bring it to an end. If somebody is ill and cannot go on, and so the boss thinks that this person must not continue to be here, then we'll bring to an end. But dismissal, we all know the English word is to kick you out, is to fire you.
So that can only be done by the boss, the employer. And
that will be based on. But how can you employee dismiss? You can't dismiss your boss. So it's only done by the man who has employed you, and that might be for genuine reasons, maybe misconduct, maybe generally misconduct.
And you get to lose a lot of the conditions that we mentioned earlier, maybe remuneration, the 1 month, and all of that.
Absolutely,
may not be paid to you when you are dismissed. Absolutely,
and in some contract of employment, like you indicated, this will be couched in some of the terms, that in the event that misconduct, blah 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 blah
blah, you are dismissed, you
lose your entitlement, you lose any deferred payment and all that.
Okay, thank you very much for your time this morning.